I guess we'll get started. So obviously, good afternoon. Welcome to our employment law webinar update. This is actually the first one that we've run like this. So thank you very much for joining us. There's a few familiar names on the list, so thank you for attending. We really appreciate it. Hopefully you'll find it quite useful and beneficial. For those of you that don't know, I'm Liz Chiva. I'm the director of Hallidays HR, and Lizzi, who will give you a little wave. She is our HR business partner and obviously also works at Hallidays HR with me. So we're going to take the next 45 minutes to go through a presentation with you, to look at what is on the horizon employment law-wise over the next year, so in 2024. And then rather than have kind of questions via the chat after each topic, what we're going to do is actually just save all the questions to the end, and then we should have about 15 minutes at the end to be able to answer any questions that you've got at that time. So obviously you might have noticed that we have turned your cameras off and your microphones off. That's really just so that you know, obviously we can focus on the presentation and on us, and like I say, the chat function is available for any questions that you might have. Okay, so today what we're going to look at then is we're going to look at additional statutory leave that's going to be introduced. So carers leave and neonatal care leave. We're going to look at the worker protection bill. We're going to look at changes to TUPE consultation requirements, changes to paternity leave, and flexible working requests as well. Okay, so let's have a look at February then to begin with. So we did do a post on this actually on our LinkedIn not that long ago, but for anybody that missed it, on the 13th of February, there were significant changes to the penalties that businesses face by employing illegal immigrants. So previously, each individual illegally employed person, there was a charge, if you like, or a fine of £15,000. Now that has actually tripled, and it's now £45,000 per individual. So that's obviously, you know, a massive change. And in terms of just emphasising, I think, in terms of, you know, making sure that you get your right to work checks done properly, because, you know, it was a costly business, but I guess now it's even more costly than it was before. You might have also heard in the news that on the 22nd of February, that there was some new guidance and kind of guidelines, sorry, lost my track, published by the Equality and Human Rights Commission, basically about the menopause and the workplace. So this is looking at, you know, potentially that guidance around menopause symptoms, and whether with some people that, you know, they can potentially have long-lasting, substantial impact on their day-to-day activities. So potentially that could be classed as a disability under the Equality Act going forward. So you know, it's really important to, you know, have those kind of conversations, that understanding with anybody that might be going through the menopause, but also understanding from a legal point of view that potentially there's going to be that legal obligation on you as employers to look at what reasonable adjustments that you can make in these particular scenarios. Because, you know, potentially it could be classed as disability discrimination, and obviously they could make a claim to an employment tribunal on that basis. There's also, you could also run the risk that obviously menopause isn't classed as a protected characteristic within itself. So along with the disability side of things, there's also the risk of an age discrimination claim and a sex discrimination claim. So kind of coming at it a little bit from all angles, really. But, you know, it's just kind of emphasising what a big impact menopause can have, and the importance of handling that properly. They've even gone so far, obviously, in terms of if anybody's found to be ridiculing some symptoms or behaviours that people might experience from menopause, that those could be considered as harassment. So, in terms of making sure people are trained, being aware that these are potentially really risky areas. And obviously, and there'll be a general theme, I think, throughout all what we're going to say, but getting your policies up to date, getting your procedures up to date, and making sure that you're not going to put yourself at risk at all. Okay. So moving on then to March. So first of all, looking at paternity leave. So currently, statutory paternity leave is 2 weeks. Okay, and there is a requirement for that to be taken consecutively. So in a 2-week block within 8 weeks of birth, or if it's adoption, the date of adoption. You also need to inform your employer of the intention to take this leave 15 weeks prior to the expected week of childbirth, or the placement for adoption. So the change in this legislation actually means that the 2 weeks paternity leave will be able to be taken as 2 separate blocks of 1 week, rather than the 2 consecutive weeks that it is now. And the time in which the leave can be taken has been extended from 8 weeks to 52 weeks. So then obviously got that year to be able to move to use the paternity leave. Also in terms of notice, so that's increased as well. Sorry, the notice is reduced, sorry. So it was 15 weeks notice of your intention to take the leave. It's now been reduced to 28 days. Okay, so something to bear in mind. Like I said, the changes are effective from March. It's actually the 8th of March, which they're effective from. So not too long before these guidelines come into play. And, for any, so actually what it is the 8th of March for parents where the expected week of confinement, it's all very complicated, begins after the 6th of April 2024, or if it's for adoptive parents, then it's if the placement date is from the 6th of April 2024. Okay. So other changes then for March. So sorry to mention the C word. I think we'd all kind of hope that this was well and truly out of our vocabulary by now. But those of you might remember that back during COVID, that they actually, for people who were on furlough or who were off sick and who weren't able to, or even who had a really excessive workload, in fact, and weren't able to take their holidays as a result of COVID, they were given a 2-year window in order to use their annual leave requirement for over that period. Now that actually legally expires on the 31st of March, so the end of this month. Obviously, they kind of said that, from a company's point of view, you're not legally obligated to extend it further than that. However, if for whatever reason you still have people with quite a lot of leave outstanding, you can choose to extend it if you'd like to do that. But like I say, there's no legal obligation to for you to do so. Okay.
Sorry, Liz, I think you said 31st of March, end of this month.
Oh, yeah.
You're wishing the days away.
Already. I'm in March already. Sorry, I'm literally a month away. Sorry, I'm just wishing this February away, I think. Okay, yeah, thanks for that, Lizzie. Sorry. Okay, then in April, then. So as usual, there's an increase in all of the statutory rates from the 6th of April 2024. So the table shows you this quite clearly. Obviously, you've got all of your kind of national minimum wage limits. I think one of the main things that's happening from the 6th of April this year is that to make note of is that the national living wage actually applies to anyone aged 21 and over, whereas it was aged 23 and over. So really important to make sure that you kind of got those, you've got that in place and set up ready for the 6th of April. In terms of the statutory sick pay benefits, so currently it's £99.35 a week. It's going up to £116.75. Statutory maternity pay is going from 156.66 to 184.03, and the same for paternity and adoption pay. Okay. So, this carers leave is actually a new piece of legislation. So it's a statutory requirement that's coming into force from the 6th of April. So basically, all employees, so irrespective of length of service, so from day one, basically, they will be entitled to 1 week's unpaid leave per year to care for a dependent who has a mental or physical illness or injury that means that they're expected to need care for more than a 3-month period. They've got a disability as defined by the Equality Act, or the care, they need care because of their old age. Okay, so the dependent, I think it's important to note that the dependent doesn't need to be a family member. So it can be someone that the employee is just close to. It might be an elderly neighbour, something like that. And this isn't meant to be for just looking after a child. So there is a separate parental leave policy which will apply and which will give employees time off to be able to look after their children. This is slightly different to that. The leave of a week doesn't have to be taken in a single block. So it can be taken flexibly. It can include half days or obviously full days. The notice required to take this leave is a minimum of 3 days. So for any requests that are either half a day or a day, the minimum notice to give is 3 days. But for 2 days or more, then they basically require twice as much time as the intended leave time. So a bit like how we would do it if we were going to enforce somebody to take annual leave, for example. So, if somebody had requested to take 3 days leave, then they would need to give 6 days notice because it's double the time. Okay. The employee does need to put a request into the employer stating who the dependent is that they are caring for, but they do not need to provide evidence. Okay, so it wouldn't be appropriate for them to prove, if you like, that they have these caring responsibilities. Now, in terms of refusing a request, so this isn't actually something that you can do, but if there are kind of significant reasons why it would impact the business if this person was allowed to take the leave, then you can rearrange it for a different time. Okay, and what would need to happen is that you would need to inform the employee of that delay, the reason for the delay, and then agree another date within 1 month of the requested date for leave. And you also need to put this in writing within 7 days of the original request. Okay. In terms of, carers leave, as I mentioned, it is a statutory leave entitlement. So employees will be protected, so that they won't be able to be dismissed kind of automatically for just taking carers leave. And, like I said, this is an unpaid policy, if you like, a legislation. But if you wanted to kind of be more generous than that, or, discretionary, wanted to pay for it, then, you're absolutely within your rights to think, do you know what, actually, we're going to give this as full pay, half pay, whatever you deem appropriate. Okay. Okay, just next up then. So protection from redundancies. So the new rules take effect from the 6th of April. And under the current rules, employers are obliged to offer employees on maternity leave, shared parental leave, or adoption leave, an available alternative post as a priority over anybody else who is provisionally selected for redundancy. Okay, so even if they're not the most qualified, they would get that role over somebody else at the moment if they are on those leaves. The amendment to the bill will mean that protection will apply from the point of which the employee informs the employer that they are pregnant. So that's either verbally or in writing, and it will actually end 18 months after the birth of the child. Okay, so this 18-month window ensures that a parent returning from a year of leave, so like I say, whether it's maternity, adoption, shared parental leave, that they get an additional 6 months protection of redundancy once they come back to work. Okay. Okay, so flexible working requests then. So just finally from me on this before we move on to Lizzie. There are some changes that are going to be taking place again from the 6th of April. So there's lots going on from the 6th of April. Now, these are changes that have been spoken about for quite a long time actually now, but are actually coming into force. So the changes are that the right to request flexible working is going to become a day one right. Okay, so at the moment, an employee has to be employed for 26 weeks before they can make any kind of claim for flexible working. So it also prohibits employers from rejecting an application without actually having discussed the flexible working request and explored other options with the employees. So, you know, sometimes it wasn't against the policy to be able to kind of say, you know, I've just rejected it. It's not feasible for, you know, these are the statutory reasons, you know, that won't be allowed anymore. And there will have to be a conversation, some back and forth discussion around, you know, what does it actually mean and what are the the reasons why potentially we can or can't do this particular request. Employees will be able to make 2 flexible working requests in a 12-month period, whereas they're only allowed to make 1 at the moment. And employees must respond to flexible working requests within 2 months now, rather than 3, as it was previously. It also removes the requirement for the employee to specify kind of what the potential impact they think will be on the business, and to suggest ways in which they think that could be mitigated. Okay, so that's kind of, those are kind of not appropriate, if you like, questions going forward. Okay, so in terms of what that means for you, I think, you know, I think it's going to be wise to anticipate that you potentially are going to get more flexible working requests from people now. You might even, you know, start talking about these things in your recruitment kind of practices, on your onboarding, that type of thing. So I guess it's, you know, just really to be aware that it is that day one right, and, you know, make sure obviously that your policies are adjusted, your managers are trained, you've got all your, you know, appropriate kind of forms and that type of thing, just to set you up for success with that, really. Okay, I'm going to hand over to Lizzie now, who's going to take you forward for the rest of the year.
Okay, thanks, Liz. Okay, so coming up in July then, as well as hopefully some warmer weather, we have TUPE consultation requirements. So some of you may be aware that currently employee representatives must be elected for consultation on a TUPE transfer, and that businesses are not actually able to consult with employees directly. However, for TUPE transfers that are taking place on or after the 1st of July 2024, employers will be able to consult directly with employees instead of having to elect and consult with employee representatives. And this will apply where the employer is a small business with less than 50 employees and or it's a small transfer with less than 10 employees. So currently, you have to go through the whole ballot, getting, people to vote and whatnot. That will actually be removed from the 1st of July. So it should hopefully make kind of TUPE consultations, if you indeed have to go through them, a little bit quicker, ideally. Okay, moving on then to September. We've got what's called predictable terms and conditions. So on the 18th of September last year, the Workers Act 2023 was actually passed. So this act establishes a new statutory entitlement for workers under a typical contract to seek more predictable terms and conditions of work. So this encompasses individuals such as fixed term workers, agency workers, and those engaged under 0-hour contracts. And it's important to remember that this is a new right to request more predictable hours only, and it is not a right to an automatic change. So obviously it's kind of, we're a few months off. Well, obviously we'll soon be here in September, but we are a few months off yet. So, we're led to believe that in terms of kind of length of service required to make a request, it will be 26 weeks. But we're hoping for kind of some more guidance and regulations to come out over time. So as soon as we hear more, we will of course share that and let people know. Okay. So in October then, moving on, we've got what's called the Worker Protection Bill. So this is intended to be implemented on about 26th of October. Obviously things could change, we'll keep you posted, but this is what we're hearing for now. So the third party harassment bill was initially meant to be included as part of this Worker Protection Bill, but this has actually now been removed. So what that would have meant, that bill would have made employers liable if their employees were sexually harassed by third parties. So this bill being removed does actually decrease the liability for employers in these cases, but it is of course still important to have kind of preventative measures and approaches in place wherever possible. So the actual wording, if you want to kind of dig a little deeper, that's what's been amended. So employers now, well, from October, will have to take reasonable steps, whereas previously it was all reasonable steps to prevent harassment. Okay, so it has, like I say, it has kind of decreased that liability slightly for employers. So in terms of what this could mean for you and kind of some of the things that that could be done, as I say, whilst the bill has been relaxed slightly from what was initially proposed, there is still an increased duty on employers to prevent sexual harassment. And sexual harassment claims can indeed carry significant costs at a tribunal. So, as Liz said, that kind of message throughout all of this is it's important to review all of your current policies and practices. And then ultimately you would have to be able to evidence that you have taken those reasonable steps to prevent sexual harassment. So providing training, etc., is absolutely essential. And I just actually wanted to just share a case on this exact example, which was Lyons versus Star Plan Furniture Limited. So Shirley Lyons claimed to her employer that her colleague had hugged her from behind without her consent and made comments about her breasts at a work party. He also suggested they might have an affair and touched her bottom. So as a result of that, Shirley raised a grievance and then claimed she was victimised by some of her other colleagues. She then resigned and put in a claim for constructive dismissal, and her case was partially upheld and she was awarded £19,000. So obviously we just want to stress the importance of having policies, training managers, employees, to make sure that any kind of claims made within the business are indeed addressed properly. And I think, some of the key takeaways from this case, it was noted by the tribunal that the company had not put in place any guidelines or instructions They hadn't identified kind of what the standards of behaviour are, you know, when we're out partying, if we're consuming alcohol, you know, what does that kind of look like? You know, we are still representing the business when we are at a work party. So kind of setting those standards of behaviour right from the offset. And without making clear to employees those standards of behaviour at work and at social events, in all honesty, employers would struggle to convince a tribunal that those reasonable steps have been taken. So the case does indeed pose an important reminder on the importance of taking sexual harassment seriously and being mindful that, you know, parties potentially are a common place where sexual harassment could occur. So, as I said, some of the things that you could kind of consider are to make sure that you've got a clear policy on how and where to report certain types of harassment and indeed sexual harassment, to provide training that could be kind of online e-learning training. You could carry out in-person training on sexual harassment, but ultimately having that clear process so that it's laid out in terms of how those claims and allegations are going to be investigated, and making sure that employees and indeed everybody know what behaviour could potentially constitute sexual harassment. So yeah, quite an important one to kind of consider there. Okay, so lots going on this year, definitely. Just one other further employment law change that we've been made aware of that's kind of on the horizon, some of you may have heard of it, is what's called neonatal care leave. So this is actually planned for 2025, and this is another type of leave that will become a statutory policy. So it's anticipated that the entitlement to the leave will be a day one right. And neonatal leave will be an additional to existing leaves such as maternity, paternity, shared parental leave, and indeed adoption. And I think, you know, the government have kind of, you know, they've taken note that, you know, in the UK, around 8% of births are premature. So it's around 60,000 babies. So the government are therefore looking to introduce such leave to obviously support those parents that are in this position. So we're led to believe that employees who have 26 weeks service as at the expected week of confinement, so the due date essentially, or when the placement for adoption is, will be entitled to receive an extra 12 weeks pay on top of the existing pay that they are entitled to. So there's differences between eligibility for the leave and eligibility for the pay. But yeah, once that's kind of introduced, we'll obviously be sharing more on that so that you know. Okay. And that actually, believe it or not, kind of sums up the employment law changes for this year and indeed the coming year. So, I mean, I don't know if we've got any questions in the chat. If anybody has got any questions about any of the topics that we've mentioned here, or indeed any other HR questions while we're here, please feel free to pop them in the chat and we will seek to answer them for you. Is there anything there, Liz?
There's nothing there.
I'm screen sharing, so I'm handing over the authority to you to check.
I'm hoping we have activated it.
You're giving it a little test just to see. Somebody write hi, just so we know.
Oh, I put ant questions, which is obviously any questions. We'll give it a minute or two. If there's no questions, then, you know, obviously, you know, we'll at the end of this presentation, we'll put our email address, which, you know, a few of you have that already, and, you know, our phone number and things like that. So, you know, we can you can just send us questions directly or give, you know, that's absolutely fine. It is quite a lot to kind of get your head round, because there is quite a lot of changes happening this year. So, you know, yeah, there's a lot going on, but don't worry, you know, obviously we'll keep you updated as much as we can. Do you want to just skip on? There's just a few comments, which is great. Thank you very much. They just said no questions, but thank you very much. Really informative. Thank you very much. Thank you very much. Can we have a copy of the PowerPoint, please? And absolutely. So, and As you've probably seen, we've recorded this webinar, so it's going to be available on our website. We'll also be able to send you the link afterwards, and we can send you a copy of the slides as well. That's no problem at all. Obviously, we can also support with any of this. So like I say, you know, if you're a client of ours at Hallidays HR, then, you know, by all means, just, you know, drop us a line. We can signpost you. We'll obviously signpost you even more in terms of as and when it comes up, and looking at your contracts and handbooks and all of that good stuff. But those of you, I guess, that don't work with us currently, you know, we'd be more than happy to take a look at your documents that you've got at the moment. So, you know, doing a bit of a gap analysis around your contracts and your handbooks, seeing maybe, you know, what's great, but also potentially what's missing, and getting you prepared for potentially these new policies and procedures that are coming in. So, you know, please don't hesitate to get in touch. We're always happy to have a conversation. It's absolutely no obligation to sign up with us. You know, we're just, you know, happy to help really wherever we can. Okay. Oh, actually, we do have, so Nigel has says, how best do we introduce you to companies, clients, etc., that we see not implementing these changes? Yeah, not really for us to criticize or comment. So, you know, like I said, if you know, if people kind of, I think often people can go around in a bit of a bubble, kind of ignorance is bliss, and just I think that awareness of there is so much on the horizon, and especially from April time, there's so much on the horizon. So I think it's about maybe if you're meeting people, about asking them, you know, do you know that employment law changes every April and October? Do you know what's coming up? You know, if you're not quite sure, do you want to have a conversation with Liz and Lizzie at Hallidays HR? You know, like I said, no obligation, happy to have a chat anytime. And if you, Lizzie, you're able just to click to the next slide, because and the next one. So yeah, sorry, there's just our email address on there, our phone number, and like I say, in the follow-up email, we'll be able to send out our website address and other ways to contact us. Any other questions before we leave you to your afternoon after only 35 minutes when we said we would take an hour? So look how good we are at giving you some time back for you to do your value-added tasks.
Or get lunch.
Okay, that's brilliant then. Thank you very much for coming along. We really appreciate it, and we will send you the follow-up shortly after this. Thanks very much.